the rulings that I made during the trial, for I tried my best to follow the rule of law in making my rulings. I know many, if not all of you, have taken notes during this trial. That's perfectly fine. The purpose of the notes is to refresh your own memory, not to tell another juror that his or her memory is wrong because they differ from what you have written down in your notes. Once you go back to the jury room to deliberate, the exhibits will be brought back to you. The attorneys and I will go through those exhibits before they're sent back to you to make sure that everything that has been admitted into evidence is sent back to the jury room for your consideration. If you feel the necessity to ask a question of the court while you're deliberating, you would need to write that question down and then just knock on the jury room door. A deputy sheriff, Anthony, or one of the other deputies will be stationed outside of the jury room door, will bring me that written question. I'll then gather the attorneys and the parties together. We'll discuss whether we can give you an answer. Now, I do need to tell you, there's really very little that I would be able to answer for you, such as if you wanted to know a word in the instructions, a specific definition. Unless that definition is already provided, I cannot add to the instructions once I read those to you, which I will do shortly. Or if you're saying, I wish I'd had a photograph of this, or I wish I had seen this piece of evidence. If it wasn't admitted into evidence, then I cannot send it back to you while you are deliberating. As I said, Deputy Sheriff will be posted outside of the jury room door to make sure that no one interferes with your deliberations. The original set of the instructions, I've put a star in the corner, and I've also signed the last page of the instructions. So when you select a foreperson, and that's one of the first things that you should do when you go back to the jury room, I will send the original set of the instructions back with the exhibits, and the foreperson should take possession of that original of the instructions and record the verdict on the original, if you would, please. I will give a copy of the instructions to each of you to read along as I'm reading those to you. The closing arguments which you are about to hear, like opening statements, are not evidence, but as I told you as we were getting ready to get started with this trial, they are very important. The attorneys will be stressing to you those points that they think that you should focus on during your deliberations. Of course, the decision as to what you actually do focus on is completely up to you. All right, so at this time, I'm going to read the instructions to you, the law of the case. So Anthony, if you wouldn't mind passing these out to the jurors. All right, thank you. All right, in the case of the Commonwealth of Kentucky versus Brett Hankison, jury instructions. Your first duty upon returning to the jury room is to elect a foreperson. Then, under the evidence presented to you in this case, you may find the defendant, Brett Hankison, not guilty, or you may find him guilty of one or more of the following offenses: wanton endangerment in the first degree as set out in instruction number 4, and or wanton endangerment in the first degree as set out in instruction number 5, and or wanton endangerment in the first degree as set out in instruction number 6. Instruction number 1, unanimous verdict. Your verdict must be in writing, must be unanimous, and must be signed by one of you as foreperson. You shall use the verdict forms provided at the end of these instructions. Instruction number 2, presumption of innocence. The law presumes the defendant to be innocent of a crime, and the indictment shall not be considered as evidence or as having any weight against him. You shall find the defendant not guilty unless you are satisfied from the evidence alone and beyond a reasonable doubt that he is guilty. If upon the whole case you have a reasonable doubt that he is guilty, you shall find him not guilty. Instruction number 3, definitions. Serious physical injury. Physical injury which creates a substantial risk of death or which causes serious and prolonged disfigurement, prolonged impairment of health, or prolonged loss or impairment of the function of any bodily organ. Wantonly. A person acts wantonly with respect to a result or to circumstances when he is aware of and consciously disregards a substantial and unjustifiable risk that the result will occur or that the circumstances exist. The risk must be of such nature and degree that disregard thereof constitutes a gross deviation from the standard of conduct that a reasonable person would observe in the situation. Instruction number 4, wanton endangerment, first degree, as to Cody Etherton. You will find the defendant, Brett Hankison, guilty of wanton endangerment, first degree, under this instruction, if and only if you believe from the evidence beyond a reasonable doubt all of the following: that in this county, on or about March 13, 2020, and before the finding of the indictment herein, he discharged bullets from a handgun into apartment 4 of 3003 Springfield Drive that entered apartment 3 of 3003 Springfield Drive, which was occupied by Cody Etherton. That he thereby wantonly created a substantial danger of death or serious physical injury to Cody Etherton. That under the circumstances, such conduct manifested extreme indifference to the value of human life. If you find the defendant guilty under this instruction, you will say so by your verdict and no more. There will be a further proceeding at which you will fix his punishment. You shall use verdict form number 1 in reaching your verdict under this instruction. Verdict form number 1, wanton endangerment, first degree, as to Cody Etherton. We, the jury, find the defendant, Brett Hankison, not guilty of wanton endangerment, first degree, under instruction number 4. There's a line there for the foreperson signature if that is your verdict. Or we, the jury, find the defendant, Brett Hankison, guilty of wanton endangerment, first degree, under instruction number 4. Again, there's a line there for the foreperson signature if that is your verdict. Instruction number 5, wanton endangerment, first degree, as to Chelsea Napper. You will find the defendant, Brett Hankison, guilty of wanton endangerment, first degree, under this instruction, if and only if you believe from the evidence, beyond a reasonable doubt, all of the following: that in this county, on or about March 13, 2020, and before the finding of the indictment herein, he discharged bullets from a handgun into apartment 4 of 3003 Springfield Drive that entered apartment 3 of 3003 Springfield Drive, which was occupied by Chelsea Napper. That he thereby wantonly created a substantial danger of death or serious physical injury to Chelsea Napper. That under the circumstances, such conduct manifested extreme indifference to the value of human life. If you find the defendant guilty under this instruction, you will say so by your verdict and no more. There will be a further proceeding at which you will fix his punishment. You shall use verdict form number 2 in reaching your verdict under this instruction. And then verdict form number 2 is the same as verdict form number 1, except that it applies to Chelsea Napper. Instruction number 6, wanton endangerment, first degree, as to Zayden F. You will find the defendant, Brett Hankison, guilty of wanton endangerment, first degree, under this instruction, if and only if you believe from the evidence beyond a reasonable doubt all of the following: that in this county, on or about March 13, 2020, and before the finding of the indictment herein, he discharged bullets from a handgun into apartment 4 of 3003 Springfield Drive that entered apartment 3 of 3003 Springfield Drive, which was occupied by Zayden F. That he thereby wantonly created a substantial danger of death or serious physical injury to Zayden F. That under the circumstances, such conduct manifested extreme indifference to the value of human life. If you find the defendant guilty under this instruction, you will say so by your verdict and no more. There will be a further proceeding at which you will fix his punishment. You shall use verdict form number 3 in reaching your verdict under this instruction. And then verdict form number 3 applies to Zayden F., the 5-year-old child. And then I have signed the instructions at the end on the original and dated them. All right, this time you will hear closing arguments from defense counsel, Mr. Matthews, and I will tell you that each attorney has told me that they will take about an hour in presenting their closing argument to you. We will take a break between the two closing arguments. Mr. Matthews?
Thank you, Your Honor. May it please the court, Ms. Will, Mr. Finke, ladies and gentlemen, good morning. Hopefully I will not take an hour, but I don't know. I haven't timed it. Ladies and gentlemen, I'd like to start out by thanking each and every one of you for agreeing to participate in this trial. We've been here, it seems like, for long days, for a lot of days. We're now at the end. But I appreciate, I know you've paid close and careful attention. I've seen all of you during the course of this trial taking notes and paying attention. That's what we ask you to do. I'm not going to delve into all the facts. You've heard facts over and over again, and I don't think there's a whole lot of dispute between the Commonwealth and between us over most of the facts. Some of the facts are disputed, but most of the facts are not. The big dispute in this case is how do you interpret those facts? And before I get into a lot of things, I would like to, there are a few issues I'd like to discuss preliminarily. First and foremost, I think everybody in this courtroom and probably everybody in this world agrees that the death of Breonna Taylor was a terrible thing. As Brett Hankison said yesterday, it should not have occurred. I think we can all agree on that, but I think we all know that this case is not about the death of Breonna Taylor. It's about Cody Etherton, Chelsea Napper, and their son Jaden. And what happened to them is a terrible thing also. But fortunately, none of them were physically injured. You saw particularly Chelsea the other day talk about the trauma and the emotional upset that it caused she and her family. And there's no disputing that. You'll have Defendants Exhibit number 1, and I apologize for sounding a bit callous here, but you'll have Defendants Exhibit number 1 in the jury room with you, which is a copy of a civil lawsuit that they filed against Louisville Metro government, the Louisville Metro Police Department, Detective Brett Hankison, and 8 or 9 other police officers, which seeks as compensation for what they've been through in 3 different counts, $12 million and $1, 3 times over. So for a total of $36 million and $3 is what they're seeking for compensation. And while I suspect they're not going to get that kind of compensation, I believe they probably will get compensated as a result of this. That's not going to undo what happened on March the 13th, but I think it would go a long way toward alleviating some of the emotional distress that they've been put through. Ladies and gentlemen, there's a common denominator to this case, and that person is not on trial here. That's Kenneth Walker. He's the fellow who fired the bullet, the initial bullet that struck Sergeant John Mattingly while he was in the performance of his duties as a police officer, serving the search warrant at 3003 Springfield Drive. The search warrant itself was something that the officers all had a right to be where they were. They were doing what they were instructed to do. The problem is, with that search warrant, is that the officers were ill-prepared to go out to 3003 Springfield Drive, as it turns out. You know, we've heard testimony about no-knock search warrants, and you have heard those described to you as what that is. We've heard that this was served as a knock-and-announce warrant. The no-knock warrant is how it was issued. That is, the police had the right to go out to 3003 Springfield Drive to Breonna Taylor's apartment and just break in that door and search for the documents and whatever else, whatever other contraband they may have been looking for or could find. Somewhere along the line, they were told not to do that. Go out and knock and announce and let the folks know we're here. And the reason that was done is, number one, the information provided to the officers who went to 3003 Springfield at the briefing at the CID office on Ormsby before everybody went out on these different search warrants was that at 3003 Springfield Apartment 4 there was a single female living there who had no children, no pets. There was nothing there to indicate that there would be any problems with the execution of the search warrant, no issues. So it was considered a low-risk entry that they were going to make. So be courteous, knock and announce, and let somebody know we're here and give them a chance to answer the door. Well, what happens? The police show up, they knock and announce, and there's been a lot of controversy about whether knocking and announcing occurred. Every officer who testified here said that we knocked for a prolonged period of time. We announced ourselves as police officers, and the issue is, are the officers telling the truth? Well, we heard from Aaron Sarpay, the neighbor from upstairs in apartment 8, not the neighbor, he was in apartment 8 upstairs picking up his daughter from the babysitter. He came in, and in the courtroom here, he denied hearing that the police announced themselves or identified themselves as police officers. But you heard a taped statement that he gave to Detective Herman Hall with the Kentucky Attorney General's office early in the investigation, admitting, or not admitting, but stating that he heard the police announce themselves and identify themselves as police. He's backed off of that at this point for some reason, but he heard it. He's an independent witness who verified that the police did identify themselves. So that's the irony of that situation is that had the police gone out there and done a no-knock warrant and just broke in the apartment, nobody would have had an opportunity to get a gun and shoot Sergeant John Mattingly. They would have been taken, in all likelihood, taken by surprise, and this incident never would have occurred. Aaron Sarpay, remember his testimony. He number one, he said police identified themselves as police. He also said that when the entry was made, he was back in the apartment 8, because he and Brett Hankison had a little disagreement about him being outside and him wanting to come out. Brett sent him back in the apartment. He went back in, but he said when they broke into that apartment, it sounded like a machine gun going off. He's an Iraqi war veteran, and he knows what the sound of a machine gun is. He said it sounded like a machine gun going off. And that kind of sets the tone for what Brett Hankison was appreciating at the same time and why Brett did what he did. Aaron Sarpay recovered, as you'll recall, and I don't know if this is has any bearing on this case, but I thought it was somewhat important to discuss, and that is the .223 spent casing that Aaron Sarpay found in the gravel that was between the sidewalk and the patios of these apartments at 3003 Springfield. We heard testimony that an AR-15, that's the type of ammunition that gun uses, that rifle uses. You heard Brett Hankison testify that when he saw the muzzle flash as Kenneth Walker discharged his weapon, or whoever shot the Luger, the 9mm gun that struck John Mattingly, you heard Brett say he thought that he saw in the muzzle flash an AR-15 rifle, person in a rifle stance. Well, Aaron Sarpay recovers a .223 spent casing outside. So what? Not a big deal. Curious, but probably doesn't mean anything. But then later on, we get another report that there's a .223 spent shell casing found in the bedroom in apartment 4 that was apparently missed by the crime scene unit when they methodically and completely searched apartment 4. They didn't find it, but at some point that casing was turned over to the FBI. It was found in the bedroom where the gun that was used to shoot Sergeant Mattingly happened to be found, and where the window was located that Brett Hankison fired 5 rounds through on this night. Now, again, does that mean anything? Is it a coincidence? Well, we heard Bryce Ziegler, the FBI criminalist fellow who did the firearms examination. He said the spent casing found by Aaron Sarpay and the spent casing found in the bedroom in apartment 4 were fired by the same weapon. Now, I don't know if that means anything or not. He didn't have a weapon. There was no weapon found when CSU did their complete and methodical search. But we also know that the family of Breonna Taylor was granted access to that apartment later in the day on March 13th, the same day this incident occurred. Does that mean anything? I don't know. Is it all coincidental? Perhaps, but have a problem with coincidences sometimes. It just is a bit curious. Another issue that I find a bit curious in this case is that we know that there were 2 occupied apartments that were struck by gunfire, that of Cody Etherton and Chelsea Napper and their son Jaden. We also know that bullets traveled into apartment 8 upstairs where Aaron Sarpe was picking up his child from the babysitter. It's interesting to me, and we know from Michael Van Arsdale, the FBI trajectory expert, we know from him that the bullets that went into apartment 8 did not originate from Brett Hankison just by way of the trajectories. We know they originated from somebody firing at the front door, either Miles Cosgrove or John Mattingly. It's interesting that the only person charged with wanton endangerment for the same conduct is Brett Hankison. Why the Commonwealth chose to charge Brett Hankison with wanton endangerment is a question I've asked myself since the day that an indictment was announced, but nobody else got charged, which was the proper decision, was not to charge anybody, period. I believe, ladies and gentlemen, that Ms. Whaley or Mr. Finke in their closing argument are going to come up and talk about the rules of shooting and how Brett Hankison violated all of those rules. You know, you've heard them over and over again. You have to have a target in sight. You have to know what's in front of, behind, or beside that target. And Brett Hankison didn't do that, is the allegation. You've heard the testimony from Brett. He testified that he saw muzzle flashes at the front door of that apartment. First of all, the apartment was breached, and you have to keep in mind that this entire shooting part of this, from the breach of the door to the end of the shooting, has been described as anywhere from 5 to 15 seconds, I believe. That is fast. The criticism of Brett is that once John Mattingly, his friend, was shot and said, "I'm down," Brett moved away from the fatal funnel that's been described and around the side to the patio, to the railing, where he had a view of the sliding glass door, and he saw the muzzle flashes inside of the apartment. Now, there's been testimony, I think Jason Vance described the curtains that covered the blinds that were over the bedroom windows and the sliding glass door as blackout curtains. Well, a blackout curtain implies to me that you can't see anything through it. And Brett Hankison said that he saw muzzle flashes. Now, people say, well, he couldn't have seen those muzzle flashes. Well, nobody can say what Brett Hankison saw or didn't see. Only Brett Hankison can tell you that. But you'll have with you in the jury room, Defendants Exhibit 5. And this is a picture of curtains. These are the curtains that were on the bedroom window. And you'll be able to look at that, and you can see through those. And I would suggest that blackout curtain was not an appropriate description. There were curtains, there's no question about that. But Brett said he could see muzzle flashes through it, and I think this shows that you can at least see them through the bedroom curtains. I mean, this is a good picture to show you can see through the bedroom curtains. And additionally, so the curtains, I think, are one thing. There's also, you'll have photographs that the Commonwealth introduced that show a mirror on the wall in the living room. What do mirrors do? They reflect things, and I would submit to you that potentially that mirror was reflecting muzzle flashes. So I think that the claim that Brett did not see the muzzle flashes is one that is not proven beyond a reasonable doubt by any means. The next thing is that what he said he did is in response to seeing those muzzle flashes, he perceived that his brother officers were being executed in a fatal funnel at the front door. And when he slid around the side to where that patio is and fired through the sliding glass door, he was firing at those muzzle flashes. That's not a target that is a human. You're not looking at a human being such as I'm looking at you and firing, but he is firing at muzzle flashes, which obviously had to originate from a human being. And he kept his firing inside of the apartment door. He wasn't firing at the officers who were out in the vestibule, because he didn't know they were there, or he didn't know that, or he knew they were not inside the apartment. He thought the shooter was still inside the apartment. And when the firing continued, he moved down to the bedroom window and fired through that at the location where he had initially seen the shooter who shot John Mattingly. And you're going to have Michael Van Arsdale's trajectory report back there with you in the jury room when you deliberate. And you can see, and you saw it in here, but you can review it. And the shot pattern is exactly where Brett Hankison intended those to go. Unfortunately, 3 of the shots at the muzzle flashes at the front door went astray into the apartment next door, which we know that Brett Hankison and any of the other officers who were sent out to serve that warrant had no idea existed. It's not obvious when you walk up to the place that there's an apartment right behind Breonna Taylor's apartment, and you heard Miles Cosgrove in his video deposition say an operations plan generally would include information about the layout of the place we're going to, perhaps photographs. None of that occurred. They did not have a diagram. Nobody had any knowledge other than we're going to apartment 4. And I would submit to you that Brett Hankison did not know there was an apartment behind Breonna Taylor's that his bullets could go into, and I would submit that even if he had, he did what he thought he had to do in that instant. And that's what you have to be cognizant of, is this all happened in such a short span. He's a police officer. You know, it makes me think sometimes of when the plane struck the Twin Towers on September 11th. There were pictures of people running away from the smoke and the debris and everything that was coming down. And in those same pictures, there were pictures of police officers and firefighters running toward that danger. That's what emergency personnel are taught to do. They run toward the danger, and that's what Brett Hankison did here. He could have, when he swung out, and there's been some suggestion that perhaps he abandoned his brother officers when he swung away and went around the corner. He could have run straight out to that parking lot and just kept going, but he did not. He ran around the corner and took efforts to save what he thought he was doing was saving his brother officers as they were being shot in that fatal funnel. Ladies and gentlemen, the bottom line is that through all this, the Commonwealth is trying to say that because Brett Hankison took the actions he took, he's a criminal and he deserves to be in prison. I submit that Brett Hankison's the farthest thing from that. You heard how he reacted to try to save his brother officers. You heard everything he did, police-related activities that he engaged in after the shooting was over, including calling the EMS, notifying officers to come for backup, having an officer ram the gate, setting up a perimeter around the building. He's criticized because he didn't go right to PIU. There's nobody that says that that's a mandatory requirement. Chief Conrad said that's protocol, but it's not any kind of mandatory requirement. Brett went there to check on his friend and his brother officer, John Mattingly. He didn't do anything wrong by going to the hospital before he went down to the PIU unit, where he went after he left the hospital, and where several days later he came and provided a voluntary statement as he was requested to do, and as you saw on the screen here. So he's cooperated ever since. He doesn't believe he did anything wrong. Now, having said all that, ladies and gentlemen, the issue is, did Brett do something that was an unreasonable choice in the split second that he had to make a decision of whether he should do anything or do nothing? He chose in that split second to go do what he perceived needed to be done, and that was to save his brother officers. So he simply reacted as I would believe that most police officers would react when danger presented itself. The bottom line is, ladies and gentlemen, you have to be convinced of the truth of the charges here. 3 counts of wanton endangerment beyond a reasonable doubt. And beyond a reasonable doubt is not defined in Kentucky. It's simply it'll be the final 12 of you who are sitting on the jury. It's your collective agreement on what reasonable doubt is. And I would suggest to you that this case is full of reasonable doubt as to whether Brett Hankison committed the offenses of wanton endangerment. Now, the most important part of this whole thing is the instructions the judge just read to you. She read you the instruction of what the statute of wanton endangerment says. And if you read that, it makes some sense, but you can't understand it if you don't understand the definition of wantonly. So on page 3 of those instructions, the term wantonly is defined, just as the Kentucky legislature ordered it to be defined. And if you go through that definition, ladies and gentlemen, I think if you read it all at once, it's a little bit difficult to understand, but if you break it down into sections and segments, you have to look at a person acts wantonly with respect to a result or to a circumstance described by statute defining an offense when he is aware of and consciously disregards a substantial and unjustifiable risk that the result will occur or that circumstances exist. The testimony in the case, ladies and gentlemen, again, is that Brett Hankison did not know that there was an apartment behind Breonna Taylor's apartment, apartment 4. He didn't know of the existence of apartment 3. And I would suggest to you that in order for him to have consciously disregarded a substantial and unjustifiable risk, he would have to be aware of the existence of that apartment. It doesn't say be aware of or should be aware of, it says be aware of. That means he had to know that that apartment was back there, and then he had to consciously disregard the substantial and unjustifiable risk. Well, there's two things there to consider. Number one, if you don't know it exists, how can you consciously or otherwise disregard it? And then number two is, was it unjustifiable? That's, you all have to determine. Was it the risk, even if he knew it, was it unjustifiable for him to fire in what he thought was the defense of his brother officers, who he thought were being, or perceived as being, executed in the fatal funnel? As it turns out, they were not. His perception was wrong. But remember, he had to make that split-second decision in that very short period. The next sentence of that wantonly definition says the risk must be of such nature and degree that disregard thereof constitutes a gross deviation from the standard of conduct that a reasonable person would observe in this situation. Well, was Brett Hankison's returning fire on what he perceived as someone executing his brother officers a gross deviation from the standard of conduct that a reasonable person would exercise? I would submit to you that a reasonable person would do exactly what Brett Hankison did if he sees his one brother officer being shot and perceives that his other brother officers are in the line of fire and being executed. He did what he had to do that day. The fact that his bullets traveled through apartment 4, through the drywall, common wall to apartment 3 is a terrible thing. But it's not criminal, ladies and gentlemen. It's kind of like what you might call it collateral damage. Fortunately, nobody was hurt in apartment 3, just as nobody was hurt up in apartment 8 with the bullets that went up there. But I would submit to you, ladies and gentlemen, if after you consider all this evidence, you have to come to one conclusion, and that is Brett Hankison was doing his duty that night, doing his job. Things went terribly wrong, but his actions were not criminal, and he does not deserve to be sent to prison for what happened on March the 13th, 2020. Thank you, and I would ask you, ladies and gentlemen, please bring back 3 signed not guilty verdicts. Thank you.
All right, ladies and gentlemen, as I told you, we'll take a brief break. So let's break for 10 minutes, and we'll resume the trial at 25 till 11. And please don't discuss the case with each other. Thank you.
All rise for the court and jury.
Anything to report from the break, ladies and gentlemen? All right, at this time, we will hear from the Commonwealth and Ms. Whaley.
May I please report? Mr. Matt. Members of the jury, thank you for serving on this jury. Thank you for being willing to sit here for all these days. Thank you for the attention you've given to this evidence. I say thank you, but I also say that being a juror in this country is a privilege. It's a privilege. Not very many people ever get to enjoy that privilege. We have the greatest system of justice in the world. And being a part of it in any form is indeed a privilege. And now is the most important part of your work as a juror, and that is to render a verdict, to deliberate, to decide, to make a verdict, to apply the law that the judge read to you and that you have now, to apply that law, the law of the Commonwealth, to this evidence that you've heard over these days. The law enacted by the legislature decades ago, the law that you all agreed to follow when we questioned you back at the beginning. And I specifically asked if anyone would have a problem following specifically the law of wanton endangerment. And everyone agreed. I also told you when you came back in to be questioned as a group, the Commonwealth has the burden of proof in a criminal case. The burden of proof to prove the defendant is guilty beyond a reasonable doubt, not beyond the shadow of a doubt. And you all agreed that you understood that burden of proof. And we, the Commonwealth, gladly accept that burden. That's as it should be. This is not a case to decide who is at fault for the tragic death of Breonna Taylor. This is not a case about civil rights violations under federal law or the United States Constitution. Whether this defendant or other officers involved violated Breonna Taylor's rights under the United States Constitution in some way, in some obtaining the way this search warrant was obtained, the way it was served, and the fact that she was tragically killed, should officers go to prison for violating the federal civil rights laws, is not your decision. You heard the FBI was given all the evidence in this case from Detective Hall, including the gun you saw that was used by the defendant that night, that was brought in here in an evidence box so the firearms examiners could show you that gun, and then was taken back. And this is not a case about Kenneth Walker. Whether what he did that night was right or wrong, this is not your decision. Under the law of the Commonwealth, you have seen and have in evidence the search warrant signed by a judge in Jefferson County, a valid search warrant, a legal search warrant signed by a judge. This is not about how the case was investigated before that search warrant was obtained. That is not your decision. Because there's one thing that is a fact. There was no search warrant for Cody and Chelsea's apartment. And that's what this case is about. This case is about the actions of Brett Hankison when he shot into the side of that building in the opposite direction from those who were in the line of fire coming out of the apartment. The evidence that you've seen from the Commonwealth and the defendant's testimony is that he is guilty under this law of wanton endangerment of Cody, Chelsea, and 5-year-old Zayden, whose head was on the pillow right in the corner of that bedroom, closest to where the bullets were flying through. He is who this case is about. Five-year-old child. You didn't hear from him. But that's who this case is about. He's one of the 3 victims who had no idea when he went to bed that night on March 12th what was going to happen in the middle of the night. And it's about Cody, also fast asleep that night, thinking it was an ordinary night, sleeping, and then, boom, awakened out of a sound sleep, and then fast walking to his door to see what is going on, but couldn't even make it to the door because of the debris flying through the wall. Couldn't even make it to the door. And it's about Chelsea. Now she told you she's a heavy sleeper. But even she woke up, was pulled awake out of that sound sleep by the noise, the boom. And was so terrified, when she reached for her phone to call her grandma, her first instinct, call grandma. And what did she tell you? Her grandma couldn't even understand what she was saying on the phone. That's the kind of trauma she was in. Couldn't even understand what she was saying. And just said, call 911. Call 911. And she did. And you heard not one, but 2 911 calls that Chelsea made. Those calls, and you can ask to hear any of this evidence again. Witness testimony, including the 911 calls, videos, you can ask to see any of that. Those calls were so chilling. The voice and the 911 operator, which of course is they're trained to do, so matter of fact. What is your location? So matter of fact. No kind of comfort. Not the operator's fault, of course, but you can hear the fear in Chelsea's voice. The FBI analyst Mike Van Arsdale showed you what you need to know about these bullets that he shot. In the graphic that he constructed from being there at the scene in June of 2020 when the FBI went in and pulled bullets out of the walls which hadn't previously been retrieved. When PIU was there that night, they collected everything that was laying there, all the casings, all the bullets in the apartment that had been shot from the door. A few of the bullets that had been shot by the defendant in the opposite direction from those who were in the line of fire. And this graphic reconstruction tells you everything you need to know about where he shot compared to those who were in danger, compared to those who were in the line of fire, in the doorway, when the one bullet was shot out the doorway that was found in the breezeway. One bullet, not an AR. One casing from that 9mm found in the hallway. One bullet found in the breezeway. One 9mm found under the bed. You heard from Mike Nobles, the detective who had the ram. Walking up as they were entering, he couldn't see in those sliding doors. There's vertical blinds and there's curtains, drapes, full length. And you'll see in the photos, you saw already in the photos. He couldn't see into those. Nobles is the one who had the ram. Nobles told you he was distracted as he was standing there in the doorway as they were knocking, distracted by Hankison arguing with Mr. Sarpe upstairs. I think all the detectives who you heard talked about this distraction caused by the defendant arguing with Mr. Sarpe. Detective Nobles testified he never saw Hankison in the doorway. He said Hankison was by the steps. That's where he was, at the end of the steps. That's why he could see Sarpe up there, Mr. Sarpe, and was continuing to be confrontational with Sarpe. Detective Nobles told you Miles Cosgrove was the one standing over John Mattingly, returning fire after Mattingly was shot. Tony James told you, as he was approaching down the sidewalk, he couldn't see through those sliding glass doors. He was the one with the ballistic shield. he took a position over by the wall right next to the door that says number 3 on it. There is no way any one of those officers who walked up to that breezeway could have failed to see 4 doors in that breezeway where you all went. 1, 2, 3, and 4. Or could have failed to see upstairs. Mr. Sarpe walked out of apartment 8. A door right next to 8, 7. A door right next to 7, 6. A door over to the left, 5. In the same configuration as the first floor. Now, I'll talk a little bit more about that in a few minutes. Tony James told you he also heard the defendant engaging with Mr. Sarpe. And Tony James testified they were very loud about this argument going on. And Tony James told you he did not shoot. Now, unlike Detective Nobles, who had the ram and didn't have his gun at the ready, Tony James did. But when the shooting began, he was engaged in getting out of the line of fire and getting out of there. And seeing what could be done to help Mattingly. He did not shoot. He did the right thing. You didn't hear anything about Mike Campbell shooting either. Mike Campbell was at the rear, at the back corner to the left as you're facing the breezeway. Mike Campbell testified that he saw Sergeant Mattingly return fire after the shot came out of the apartment, after the door was breached. He saw Mattingly return fire. Now, Mike Campbell had a good perspective back there, and he could see. He testified he saw Sergeant Mattingly return fire, and he saw Detective Cosgrove return fire through the doorway. He testified he did not see where Hankison was, and he had no idea what he was doing. Mike Campbell also testified Mike, did not shoot. Obviously, Mike Campbell and Tony James were in emotional reaction, trauma, when they realized there was a shot been fired out that door and hit Mattingly. They didn't wantonly just start shooting in revenge. They didn't start shooting in revenge. Well, our fellow officer was shot, so we need to shoot back. No. Mike Campbell got out of there and started doing what he could to help Mattingly. He did not shoot. Miles Cosgrove, who you heard from his deposition, also said Hankison was arguing with Mr. Sarpe, and he used the words yelling. Hankison was yelling at him. Miles Cosgrove realized no one was behind Nobles, who had the ram, to cover Nobles, because Nobles didn't have a gun. He had the ram, or he didn't have his gun drawn. So Cosgrove moved up. Once the ram starts the first hit, Cosgrove moves up to cover Nobles. That's why he was in the threshold, in the line of fire. After Nobles breaches, Nobles spins out of the way to the right. You saw the ram laying on the ground there to the right of the door. So that's where Cosgrove is when the door is open. He was in the threshold after Nobles spun around. Cosgrove said he saw the figure in front of him and he saw the gunshot fired at him, and he fired back. You know from the round counts that were done at Public Integrity Unit where all of the officers guns were taken down there and unloaded with the magazines unloaded. That's called the round count, how many rounds were missing. So it could be determined how many shots were fired by each one of the three who shot. Mattingly fired 6 shots. There were 6 rounds unaccounted for in his round count. Cosgrove fired 16 shots in the doorway. Mattingly, 16 shots from the doorway. Lieutenant Lacefield, the firearms instructor commander, told you, when asked, how long does it take with this Glock 40 caliber Model 22, the service weapon, the one you saw, how long does it take to shoot all of the 16 rounds in that gun, which it can hold if it's fully loaded with one in the chamber? And he said 4 to 5 seconds. 4 to 5 seconds. Cosgrove said he did not realize he had shot 16, but all of his shots are here in the doorway after the shot came out and hit Mattingly. He was in the line of fire. Hankison's round count, 10 rounds missing. And all his casings are accounted for. All his casings are accounted for out here in the parking lot, 10 of them. All these casings that you'll see in the photo in the breezeway were identified by the Kentucky State Police firearms examiner Stephen Hughes as having been fired from Cosgrove and Mattingly's guns, because that's where they were, in the doorway, responding to incoming shot from the hallway. One shot, one bullet, which went through Mattingly's leg and was found over by apartment 1 door. I know you all have heard the old saying, a picture is worth 1,000 words. So, nothing can take us there to actually witness what happened. But I want to go back over some of these photos to refresh your memory of some of the testimony. This is the overhead of the complex that you saw. Now, I want you to pay attention to when the defendant was on the witness stand, I asked him with this photo to show how he drove in that night and where he parked. And the road the main road out here, I guess St. Andrew's Church Road or St. Anthony Church Road, out here, and then you come up this way and turn to the left and come down, because you can't get in this way, or couldn't on March 12th because of the gate here. So you come up this way, turn in to the left to this road, and drive through here and around, and this is the dumpster, and that is where, in this area, is where Hankison said he parked. Some of the other vehicles were parked in this area as well, except the white van, of course, the van that the Sequoia that Mr. Sarpe was driving was here, parked perpendicular to those, and then I believe the white SUV that Mattingly was driving, you heard, was right behind the Sequoia. But here's the important thing. When you drive in this way, it is obvious that this is a complex of apartment buildings. You drive through here and you are seeing the patio and the balcony of this two-story building. The two patios, this is only an 8-plex right here. These other three, and this one also, are 16-plex buildings. So that you have, in this one, you have 4 apartments on the first floor, 2 at the front and 2 at the front and 2 at the back. And then on the second floor, you have 4 more, 2 at the back and 2 at the front. So that you have 2 patios and 2 balconies. And then in the front, the same thing, 2 patios and 2 balconies. But in the 16-plex buildings, you have 2 on this side of the building, 2 patios, 2 balconies, and on this side, 2 patios, 2 balconies. Patios downstairs, balconies upstairs. And the same at the front. So that it's obvious as you are driving around these buildings that you see, oh, here's 2 balconies and 2 patios on this side. And over in the front, the same thing, 2 patios and 2 balconies. Same thing with the 16-plex, which this is the building, 3003, and here's number 4 right here. Before you can even get to 4, as you're walking down the sidewalk or the parking lot, you have to pass this set, which is identical to these across the street, that you have already passed as you're driving through and seen, oh, there's balconies and patios in back of these buildings. Oh, here's the front. There are patios and balconies in front. So if you're a trained observer, say for instance a police officer, a 20-year veteran police officer trained to observe your surroundings for 20 years, you're going to take note of the surroundings as you drive in and approach the target destination, which is apartment 4. These buildings are identical. So this is the back of 3003, and right here is Cody and Chelsea's patio and railing there, just like the one in the front. No, you can't see it from the front, but you can see the doors. You can see apartment 3 door with a big 3 on it within 3 feet. You all were there. Within 3 feet of apartment 4 is the door right there with a big 3 on it. But you've already seen these buildings driving in. Oh, there's patios at the back, identical to these. Next photo. And here we have the breezeway. And actually, even in this photo, it looks larger than it is. In reality, it's just makes it look larger than it is. But you see how close these two doors, this is apartment 2, and then directly across, this is apartment 4, of course, directly across here was the door to apartment 1. There is no way that he didn't know. There's another apartment right here. Next photo. Another photo of the breezeway, and now we can see apartment 1 door, 2, 3, and here's 4. And this was taken, and you heard Lieutenant Vance testify about the Sergeant Vance, I think. Markers. These all represent casings collected. All the .40 caliber casings from the guns of Mattingly and Cosgrove, because that's where they were when they shot from the line of fire. And here, marker 37 is the bullet that was collected, that was identified by the FBI firearms examiner Bryce Ziegler, this bullet here, as having been fired from the 9mm found under the bed in the south bedroom of apartment 4. The bullet that went through Mattingly's leg and ended up right here. The rest of these markers are all casings that were ejected by the guns of Mattingly and Cosgrove because they were the ones in the line of fire, not this defendant. He was over here, shooting wildly through sliding glass doors covered with vertical blinds and drapes. Now, in the daylight the next day, when that picture counsel showed you of the bedroom window with the black drape, that was taken the next day in the daylight. And he wanted you to see or believe that you could see through it because, oh, by now it has bullet holes in it. And it's daylight, so yes, you can see daylight through the bullet holes the next day. But not that night. Next photo. These markers are the defendant's casings. Every one of these, 5, 6, 7, 8, 9 is under the tire, 10. Here is the sliding door with the bullet holes in it, and the window with 5 bullet holes. 5 bullet holes in the sliding door and 5 bullet holes in the window. And here's the casings. These up here in the gravel were testified about by Sergeant Vance that were weathered casings, and you may have noticed some when you were out there that were laying and had been there a while. So these up here in the gravel were not relevant. These, all in the parking lot, were identified by Kentucky State Police Examiner Stephen Hughes as having been fired from the defendant's service weapon. Every one of these casings was a positive identification by Stephen Hughes with Hankison's .40 caliber Glock. Next slide. And here's two more. This is not a casing. This was a magazine that was dropped. 1 and 3, marker 1 and 3, are two more of Hankison's casings, both identified as positively having been fired from his service weapon. Next slide. Again, 1, 3, and now you can see marker 4 between the two vehicles in the parking lot, another casing that was positively identified as having been fired from Hankison's gun. Next slide. Close-up of the sliding doors. Now, obviously, we can see through them now because the curtains are pulled back, the blinds have been pulled back so that they can see the bullet hole, the bullet defect. 1, 2, 3, 4, 5. And shattered glass. Next. Now this, we're going to follow the pattern of those 5 bullet holes we just saw. So this is taken from the inside, of course, and they have pulled the curtains back, and you can see the bullet defects in those. Here you can see some of the blinds that had been broken down during the shooting. And you can see shattered glass here, but some of the vertical blinds that are now laying on the floor. Next. Now, the bullets have been shot through the sliding glass doors, and here is where they went through the wall that's straight ahead, looking through the sliding doors. This wall is straight ahead. So this is the common wall with apartment 3. And we have one defect here, which this bullet is the one that ended up falling down and was laying on the carpet. So that's that one there that was collected. And later identified by FBI examiner Ziegler, he described it as a bullet jacket that was found here. It didn't make it through, and he identified it positively as having been fired from Hankison's gun. So that's one. And then we have 2, 3, 4 bullet holes here. Next slide. And now we can see the 5th one. First one was the chair. Now we can see 2, 3, 4, 5 holes going into the wall. And next. And now we can see the trajectory rods that Examiner Van Arsdale, who created the graphic, during his work, he was measuring from the entry hole into this wall through to the drywall of apartment 3, where he could still see, even though the drywall had been repaired in apartment 3, he could still see where the hole had been in order to make this trajectory. These are the 2 clock defects right here, which you'll see on the other side. And then you'll see this one. This hole here is one that the bullet ended up in the stud. So this is the stud, and the bullet was pulled out of the stud by the FBI, and it was identified by firearms examiner Ziegler as having been positively fired from the defendant Hankison's gun. This one. These 3, this one, these are the 2 clock ones you'll see, and then this is the one that went straight through to the chair rail or bumper on the other side of the wall. Next. So now this is apartment 3, where they have come through the bullets. It's a mirror image of the other wall. So here's the clock, defect here, or bullet coming through here, bullet coming through here. And then the third one would be the next slide. Third. So there's the chair rail in apartment 3 that mirrors the entry hole on apartment 4, and here's the exit on apartment 3. Now we'll see where this bullet, and there's this bullet, ends up on the dining room table of apartment 3 that came through over the chair rail. Next slide. Now the second bullet that was found that came through one of the bullets came through the clock, we'll see in the next photo, hit up here and then dropped down on this carpet. Next slide. So here is the bullet. One of the bullets that came through the clock and then hit up above the sliding doors and then dropped down on the carpet. That's the second bullet they retrieved from apartment 3. Next slide. And here is the hole in the vertical blind where one of the bullets that went through the clock kept on going, and that's where the one that probably almost hit Cody as he was walking through, it went all the way through the blind and shattered the sliding glass door. This other bullet from the clock ends up here, doesn't make it through, and falls back down on the carpet. So this is the one that shattered that door and left then it wide open with shattered glass everywhere. Next slide. The window bullets. This is the 5 window bullets. 1, 2, 3, 4. 1, 2, 3, 4, 5. You can see here, this of course is taken in daylight the next day. You can see these are the horizontal blinds. Now you see how close those blinds are together? Well, those were down. There's defects in them now. And covered by the black curtain on the other side. Next photo. And here's the other side where those bullets came through. Fired from here on the graphic. So 5 bullets were fired at that window. One of them you heard about was found, it came through and hit this dresser drawer and then ended up inside the dresser drawer. That's one. And the next. 2 more hit this wall as you're facing the window. It'd be the wall to the right. And there's the defects. And those 2 were later found in the wall by the FBI in the search in June. Those 2 were pulled out and they were tested by Bryce Ziegler and found to be a positive identification to Hankison's gun. These 2 bullets here pulled out of the wall. So that's 3 bullets so far from the window that were retrieved. Next slide. So here's the 4th one. This went into the utility closet in the hallway here. And there it is, the bullet right there. That was retrieved, and that was positively identified as having been fired from Hankison's gun. That one was retrieved during the crime scene unit search, and that one was identified by the state police as having been fired from the gun of Hankison. Next slide. And this is the 5th bullet through the window that was found in the soap dish. Obviously, you don't see any defect behind it, but must have ricocheted from somewhere in here And here it is, right there. The fifth bullet through the window. So we accounted for all 5 in the sliding door because we had the one that hit the chair and fell on the floor. That's 1. One that got stuck in the stud that was pulled out later, that's 2. And then 3 of the ones fired through the sliding door that went all the way into apartment 3. Those are the 3 important ones. Because any one of those 3, 2 that went through the clock, especially those 2, that went through the clock and then through the clock in apartment 3, and 1 all the way out the sliding door, could have, any one of those. In fact, any one of the 3, even the one that went through the chair rail and ended up on the dining room table in apartment 3, could have taken another deflection. You know, who knows where it could have deflected out of that clock. Instead of going through the sliding door in there, could have gone into that bedroom where little Zayden had his head on the pillow. Next. And here is the 9mm that was found under the bed in apartment 4. Right here is the south bedroom, found under the bed. That was collected, tested by both the Kentucky State Police, the Kentucky State Police Examiner, Mr. Hughes, made a positive identification of the casing found in the hallway. The casing found in the hallway was fired from this 9mm. 1 casing. 1 bullet was found in the breezeway, marker 37, that the FBI examiner, Mr. Ziegler, positively identified as having been fired from this 9mm. Next. Now we're back out to the front. And we see, again, the defects, the shattered glass, the railing up, or the balcony up here. Apartment 876. There's the Christmas tree that Cody Etherton told you they had set out in this bin, and that's where it ended up. Of the, you can see the relationship between the sliding door and the window. You definitely have to change position to start shooting, stop shooting from this sliding door and start shooting through the window. It wasn't all just one action. There had to be a position change, a continuing shooting blindly into the side of this building. There were no AR bullets found anywhere. Anywhere. There were no bullet defects in apartment 4. If this person was standing here with an AR shooting out, where are these defects? Who got shot with an AR? You didn't hear any testimony that any of these officers, including Mattingly, who did get shot, but who got shot with a 9mm, one bullet. Who came in and said they were shot with an AR? There was, Cosgrove was right there. Where's the bullet defects of all this AR shooting going on? And there was no bullet defects in these walls. There were no bullet defects bullet defects of exiting anywhere of an AR. There were bullet defects coming in from Mattingly and Cosgrove that went in to these walls that were fired from out here. Yeah. The reason there were no AR bullets and no AR bullet holes and nobody that got shot with an AR is because there was never one. When Lieutenant Vance interviewed the defendant, he couldn't remember which way the door opened. When Lieutenant Vance asked him in that interview, which way did that door open? He couldn't remember. It's in his statement. Which way did the door open? And he responded, I can't remember. That's because he was never in the doorway. The only ones who had ARs or long rifles in that night, the only ones were the patrol officers that he called out and told, we need long rifles, we need long rifles. So you know what that did? You know what that did when they all showed up with long rifles, the patrol, all out behind that first slide that shows the overhead of the complex. And you saw on the body camera of one of the patrol officers with the long rifle pointed at Cody, and he testified he was standing there with his hands out the window of what used to be the sliding door, and they were pointing rifles at him, and there was a dog back there barking. He was afraid it was going to lunge at him. That put him at even more risk of serious physical injury or death caused by this defendant telling them to come out with long rifles. Now, I want to look at the instructions. There they were. Back here with the long rifles pointed at Cody. Instruction number 4, all the wanton endangerment ones are the same. That in this county on or about March 13th, for the finding of the indictment, he discharged bullets from a handgun into apartment 4 that entered apartment 3, which was occupied by Cody Etherton. Now, this doesn't require, nowhere in this instruction are you going to find anything that says, that asks you to find that he knew that Cody Etherton, per se, was in that apartment, obviously. You are not required to find that he knew there was a man named Cody Etherton in that apartment. If that was the case, this would be an intentional crime, not a wanton endangerment. It would be some sort of intentional. B, that he thereby wantonly created a substantial danger of death or serious physical injury to Cody Etherton. That under the circumstances, such conduct manifested extreme indifference to the value of human life. Now, and you have a definition of wantonly. But I want to look at let's look at how the evidence has proven this. First, the instruction says, he wantonly created a substantial danger of death or serious physical injury and this would be to Cody, to Chelsea, and to Zayden for each count, and that under such circumstances, such conduct manifested extreme indifference to the value of human life. So how is the evidence established this? Go on to the next. So wantonly. The definition of wantonly states a person acts wantonly with respect to a result or circumstances when he is aware of and consciously disregards a substantial and unjustifiable risk that the result will occur or that the circumstances exist. And this risk must be of such nature and degree that disregard thereof constitutes a gross deviation from the standard of conduct that a reasonable person would observe. So, you have to find that he was aware of the risk of shooting blindly into this building. There's the building. Well, there's where the bullets went through, but the building, the side of the building, the front of the building, where there was no view, through the sliding glass doors and the window. That wantonly, he has to be aware of the risk. And how do we know he's aware of the risk of shooting blindly? Well, because he has 20 years of training as a police officer. He has 20 years of twice a year having to go to the range and sit through not only classroom instruction and simulators, but actual firing at the range, shooting at a silhouette target. Because that's where you're going to be using defensive force, deadly defensive force, is against a person who's a threat. So that's why they have silhouettes shaped like a human body. And he couldn't even tell you that after Officer Gelhausen explained, yes, we use the silhouette as the target in these exercises out on the range. And we call it LMPD blue because it's a blue color. So 20 years of training, he's aware of the risk of shooting when you don't have a target. And he consciously disregarded. He ignored that risk. He consciously disregarded it. And he shot wildly in the wrong direction. And a threat can be a muzzle flash. What did Officer Gelhausen tell you about that? Seeing a muzzle flash. It can be a threat, but it has to rise to the level of an active threat. It can't just be a threat. A threat is not something that requires that you shoot at it. It has to become an active threat. There has to be a person at the end with a gun that caused that muzzle flash. It has to be an active threat. Officer Gelhausen said, if a person is standing there with it, and you can see they've got a gun even down to their side, that's a threat, but it's not an active threat. You don't have a right to shoot somebody who's just standing there with a gun down to their side. And he told you. Now, if they raise it and point it at you, then you do have a right. That's an active threat. So he was aware of the risk of shooting blindly, and he disregarded that risk and shot wildly in the wrong direction. Next. He created a substantial danger of death or serious physical injury. Cody Etherton was at absolute risk of substantial danger of death or serious physical injury. And serious physical injury is defined for you. It's very straightforward. Chelsea was in substantial danger. When those bullets came through, they could have deflected. Instead of hitting that clock and going straight through to the sliding door, any one of those 3 bullets could have deflected off that clock and gone to Chelsea's bed. Or even as she stood up. Any one of those 3 bullets could have hit little Zayden in that bed closest to the line of fire where they did come through and go out the sliding deck. A little deviation in degree and angle of those bullets as they came through this wall and through that clock and any deviation in the angle as they deflected could have hit. 3 bullets came through. Any one of those 3 could have hit Cody, Chelsea, or little Zayden. Next slide. Circumstances. So, the instructions states that that he wantonly created substantial danger of death or serious physical injury, that under the circumstances, such conduct manifested extreme indifference to the value of human life. So what are the circumstances? Okay, the circumstances under which he fired wantonly. Well, you have a 16-plex building, as I went through with that overhead, and you're driving through there, you can obviously see all these apartment buildings, and you drive right past 2 of them. You drive right past the ones that you're at the back, and you see, oh, 1, 2, 3, 4, 5, 6, and then you drive around and you see, oh, here's the front, and 8 more in the front, 8 in the back, 8 in the front. More circumstances. Testimony from the defendant himself. I told him, this is him telling Mr. Sarpy, I told him to go back in numerous times. His focus, when everybody else was focused on that door, on the knocking, on trying to get a response so they could peacefully serve the search warrant. When everybody else is focused on the job at hand, he is talking and arguing with Mr. Sarpy upstairs, taking the focus off. Mike Nobles, the one with the ram who's got the most important job at that time. Mike Nobles, the most important job, he's the one with the ram, and then they said, go ahead. He didn't want to have to use that ram. Mike Nobles, this distracted us, the argument with Sarpy, took our focus off the door. More circumstances, next slide. He's the one that directed the patrol to bring long rifles. Cody was in more danger with rifles in the back. More circumstances. His wild shooting with no target, with no reason, put fellow officers in jeopardy. His shooting from this sliding door, while they're still here in the fatal funnel, he was never in the fatal funnel, ladies and gentlemen. He was out here. His shooting wildly through this sliding door put his own fellow officers at risk. Look at this angle. They're still in the fatal funnel. Circumstances, the doors in the breezeway are clearly visible. a trained officer, trained 20 years to observe his surroundings, especially in a situation like this. What you won't find in the instructions is anything that requires you to find a motive. You're not required to find or know why he did this. You won't find that in there. You won't find anything in the instructions requiring you to find or consider whether he acted in self-defense or whether he acted in defense of another. You won't find that in the instructions because that, once again, would have required an intentional shooting. That may be something that would have been applicable to those that were in the fatal funnel who did shoot back intentionally. You won't find in these instructions anything that requires you to decide why he did this. And the facts are, he actually came in here and told you that he was standing on the doormat and saw the flash straight ahead in the hallway, and then when the hallway lit up, he saw a figure in a tactical stance with a long rifle. He actually came in here and told you that he was the one standing in the doorway and saw the shooter. Okay, well, the fact is that didn't happen. Because if he had been there, he would have shot then with a real active threat in front of him. Like you heard Mattingly and Cosgrove, who were the ones there, who were in the fatal funnel, who did take fire, who did take a bullet and fired back. If he had been the one standing there instead of Mattingly and Cosgrove, yeah, we would have a different. We wouldn't be here. It may be in another situation, but it wouldn't be. He may be in another situation, but we wouldn't be here. He was never in the line of fire. You do not have to find why he did this. Next slide. His wanton conduct could have multiplied one tragic death, Breonna Taylor. His wanton conduct could have multiplied her death by 3. Easily. This is what this case is about. This is who it's about. By grace, they're still alive. I ask that you find, based on this evidence, that this defendant is guilty of wanton endangerment under the law of Kentucky for his conduct that night. Wanton endangerment of Cody, of Chelsea, and Zayden. Thank you.
All right, ladies and gentlemen, we are very glad to still have all 15 of you with us, but only 12 by law are able to deliberate this case. So we'll randomly draw out 3 of your number, and I will call those out. When you hear your number called, just please remain seated. Juror 289-5941, Juror 289-6551, Juror 289-5881. Do you solemnly swear to keep the jury together, to allow no one to discuss the case with them, and to not do so yourself?
I will.
All right, thank you. All right, for the three of you whose number I called, could you just raise your hands, the three that I called your number? All right, if the three of you will just remain seated, and then we'll let the other 12 of you go back to the jury room to begin your deliberations. You are released from the admonition that you're not to discuss the case with each other. Please discuss the case with each other fully. As I said, we'll send the exhibits and the original of the instructions back to you in just a few minutes. I believe your lunch is either here or on its way.
Is here, if you want to have your lunch, the three that remains here, just wait and I'll bring them to you.
All rise for the reporting jury.
To the three of you whose number was chosen, you may feel some relief, you may feel some disappointment. You've sat through this trial and you've been extremely attentive, taken lots of notes. But we do all appreciate so very much the time and attention that you have paid to this case. You have helped us get through this. We're in a pandemic, and yet all 15 of you were able to be here each and every day, and we certainly are relieved for that. You are also relieved of the obligation to not speak about the case. You may want to talk with the attorneys, you may not. It might be helpful to them to hear from you, but if you wish not to speak with the attorneys or the media or anyone else, you are certainly not required to, and they will understand. As Anthony said, we do have your lunches for you. If you prefer to be escorted out by Anthony, he will be happy to do that for you. So if you will, just remain seated. I'm going to release everyone now so that they can leave the courtroom, and we will get your lunches for you. Thank you again. All right, we will be in recess until we hear back from the jury. Counsel, if you would leave me your phone numbers so that I can reach you if you're not going to be staying in the building.